My definition of lawfare, if I may be permitted to start with that, is as an abuse of law, of international law in particular, vis-a-vis Israel, of international legal institutions and international legal processes. I see this, in fact, as the weaponization of international law against the Jewish state. And while there will often be appropriate applications of law domestically and internationally, what sets lawfare aside is it's not a proper application of law. It's, as I say, the abuse of legal processes to pursue a particular legal agenda. Now, I fully accept that the term is used in different contexts and has certainly been adopted by different organizations to mean slightly different things. But when I use the term lawfare, it is not to refer to any proper practice of law, but, as I say, to its manipulation, but also its misrepresentations, because looking at the way that the law is so often misapplied to Israel, and perhaps answering the second part of your question, it's not just the legal processes that are being weaponized against the Jewish state, but it's also their public coverage of them, in which many of those legal processes, and I'm sure we'll come on to discuss the ICJ in particular, the International Court of Justice, which sits in The Hague, is the court that deals with disputes between states. Some of the ways in which the proceedings brought against Israel have been represented in the international media compound the lawfare approach by misrepresenting even what this court has so far determined vis-a-vis the Jewish state. It's an increasing phenomenon and an increasing trend. It's definitely now on people's radars far more so than it was in previous decades, but it has been with us for some time, and I hope we'll have a chance to properly unpack some of the ways that it's been developing over a number of decades.
Is it applied only, or let me say it this way, is lawfare applied only to Israel? Is Israel the only country that suffers from the application of lawfare, or is it just a matter of degree? It's applied to other countries, but it's applied in a far greater degree towards Israel.
Yeah, it's certainly not only applied against Israel, but the most severe, significant manifestations of it are certainly against Israel. But vis-a-vis the UK, I think we can also see certain proceedings concerning the Chagos Islands. I don't know how many lawyers we have on the call, but some of the audience may be aware that there was an advisory opinion sought with respect to the Chagos Islands, which is quite an unusual and many would argue inappropriate approach to take. An advisory opinion is a process which the International Court of Justice also conducts, but it ought never to engage in providing an opinion of that nature on an issue where there is a dispute between states. In that case, that dispute involved the United Kingdom. And I think there's a strong argument to say the UK's rights were ridden over roughshod to have the ability to determine where and when a dispute of that nature is considered by a court which has jurisdiction. So that's just one relatively recent example. But the reason that understanding the true manifestations of lawfare against Israel, I think, is so significant is that it has repercussions for other states, really significant ones. The more we see international law being thrown out of the window, the more susceptible other Western liberal democracies are going to be to these sorts of political attacks in these weaponized pseudo-international law institutions.
And we're going to get to that in a little while, because you raise a very interesting point. I wonder what the obligation of states will be to push back on the ICC in order to maintain credibility in the rule of law. But I'll get to that in a moment. I want to discuss the idea of lawfare as a subset of idea laundering, and idea laundering being defined as the hijacking of legitimate words, ideas, or phrases to infiltrate into the marketplace of ideas illegitimate, fabricated, or distorted ideas. And if that's the umbrella, lawfare through the ICC, ICJ, and UN could be a form of disseminating that. But we also see it in the majority of interactions which are not legal. We see it on social media. We see it on the media. We see it in debates like the monk debates that you and Douglas Murray were involved in with Mehdi Hassan and Gideon Levy. There's this discussion about very important words that have legal meanings like genocide, proportionality, occupation, borders. Could you talk about the interaction between the public sphere that engages in these legal gymnastics, defining these words, and then the legal world? You sit atop both of them. So how do you see them interacting?
Well, there's an additional area here, and that's the academy. And so far as international law is concerned, the academy has actually played a significant role in this laundry of words and the weaponization of these legal terms that are being deployed for political purposes. I think in the monk debate, I gave an example of a number of them. I'm not sure that I mentioned occupation, but I would definitely include that in a list of pseudo-legal terminology which is being misdeployed with respect to Israel for a particular purpose. So occupation, ethnic cleansing, colonialism, apartheid, and genocide. In each of these instances, not only is this legal terminology that is being wholly inappropriately applied in, I would say, all of them, the concept is actually being inverted. So we have the victims of a particular phenomenon, all of them issues in international law, that are being accused of committing that act or crime that was actually committed against them. And nowhere is this more apparent than in the context of genocide. And I can say shortly after, I think it was the day after the first provisional measures order came out from the International Court of Justice, this was on the 26th and then 27th of January last year, I was on the equivalent of the BBC in South Africa, SABC. And my counterpart, who was arguing the case for South Africa, bringing this abhorrent, obnoxious, totally baseless accusation of genocide, said something along the lines of, "Isn't it wonderful? Now we can finally use Israel and genocide in the same sentence and nobody can tell us otherwise." And that was a clear acknowledgement, as far as I was concerned, of the motivation of using these sorts of terms and then using the legal mechanisms, the legal processes, which shift the Overton window and suddenly give something that is entirely baseless and fantastical some degree of supposed credibility in the conversation and the discussion. And it's a vicious cycle and it's self-perpetuating, because the more that people are talking about Israel and genocide in the same sentence, the more credence that South Africa's application seems to be given. And now most recently we've had the intervention of Ireland to, in fact, it's been quite upfront about the fact that it is seeking to extend to amend the definition of genocide so as to try and better shoehorn what it says Israel's actions are into it. It implicitly acknowledges, I would suggest, therefore, that it does not consider Israel's activities to, in fact, be genocide, or the crime of genocide. But we're seeing this approach to weaponizing legal terminology and abusing it in this way, I think, across the board. And I think one of the reasons that these negative actors have been able to do this so successfully is that general literacy about international law is not particularly extensive. And most people, when they hear international law or international legal terminology or the allegation that Israel breaks international law, don't feel armed with the tools, with the knowledge, with the expertise to be able to properly push back on that. And we're seeing this manifesting itself at every imaginable level. So yes, at the United Nations and international legal institutions, in the academy, in the media, on social media, in schools, and TikTok, and probably in the workplace and at the water cooler. And there becomes this, generally accepted, received wisdom as a result, which is totally divorced from the reality, the facts, the law. But if you don't subscribe to it, suddenly you are the other. And absent the ability to properly explain why you don't subscribe to it, and perhaps even convince others that they have been entirely hoodwinked in this situation, I can entirely understand how it just becomes this, snowball. I think it's even more important that we do our utmost to counter it in those circumstances.
You mentioned the ICJ, so I'm going to jump ahead and ask a question about the ICJ and the two cases. So I heard you in a prior interview, you explained that the ICJ, the International Court of Justice, is having the responsibility of either offering an advisory opinion or a binding resolution of a conflict between two states. And I'm sure there are many questions, around that phrase, two states, but I have two. The first one, in the context of Israel and the Palestinian territories, does the ICJ see two states? And for the two cases brought before the ICJ, the one brought by South Africa against Israel and the one brought by Nicaragua against Germany, what legal standing, if it's between two states, what legal standing does a third party have to bring a case on behalf of one in which it has, it's two standard deviations away from the conflict? What legal standings do they have to do this?
So the first thing is, I can appreciate why this feels anathema and somewhat complex or alien, but the simple explanation that I can offer to the cases that you have outlined is the fact that if states are party to an international convention, they may bring a case or a claim or an accusation against another state in respect of that convention. So international conventions are signed up to by states. They are an important source of international law. It's a treaty-based. It's almost like a contract that you sign yourself up to. But here we're primarily talking about the Genocide Convention, the International Convention for the Prevention and Punishment of Genocide, and that is the legal hook that South Africa has used to bring Israel to the ICJ, the International Court of Justice, because both Israel and South Africa are signatories to the Genocide Convention, and South Africa is alleging that Israel has breached it. That's the jurisdictional basis for the bilateral dispute that you have seen all over the media in terms of South Africa's allegations against Israel. I mentioned that Ireland had recently joined that case as an intervener. That's entirely possible because Ireland is also a party to the Genocide Convention. And the idea behind this is that every state party is responsible for seeing the proper enforcement of that convention. Now, this is particularly interesting because my argument right at the very beginning of this war, long before South Africa had brought this case, is that every signatory to the Genocide Convention had an obligation to ensure that the genocidal acts of the 7th of October were punished and prevented, and therefore had an obligation to ensure that they were supporting Israel in every way to seek the total eradication of Hamas, the return of the hostages. That didn't particularly go very far. I mean, there are many international law obligations deriving from conventions that I'm afraid are simply not complied with. And now, of course, many of our viewers may be familiar with real genocide that is currently occurring in South Sudan. Many aspects of real breaches of international law are simply not picked up on. That is one of the big criticisms of the politicization of international law. But I hope that explains why it is that South Africa can bring this particular claim, this allegation against Israel. In terms of this idea of two states, this is the buzzword two states, of course, that applies in the context of the received wisdom of what the quote unquote only possible solution to the Middle East conflict must look like. Perhaps there'll be an opportunity to try and unpack the misguided received wisdom in that respect in due course. But it's difficult to say where either the ICJ or, for that matter, the ICC, which is the International Criminal Court, also sits in The Hague, but it deals with individual criminal responsibility. So it's not, in fact, dealing with states. But both of them have recently taken rather confused positions with respect to this question of whether there is a state of Palestine. So moving away from what a political resolution might look like and concentrating on what the current legal position is in terms of two states, it is clear, if you consider basic international law and the requirements of statehood, which are also set out, they're a matter of customary international law, but they're also set out in the Montevideo Convention. There isn't a question in my mind that there is no such thing as a state of Palestine. It does not fulfill those criteria, not least that there is a division between Fatah in the West Bank, whose authority there is governed by the international agreement under the Oslo Accords. Obviously, Hamas has controlled Gaza. It still controls significant parts of Gaza. So the idea that there is a coherent government simply doesn't exist. There are no fixed borders. There are big problems with respect to the idea that Palestine presents itself as a state just because you use the State of Palestine stamp at the bottom of some official documents. I'm afraid it's not enough. There are, of course, increasing numbers of states that have recognized the so-called State of Palestine. That's also not sufficient in international law. There's a big debate about recognition. It plays some significant role, but it cannot compensate for where the basic attributes of statehood are missing, as they are in this case.